I think we are going to get started. If everybody can have a seat, thank you all for sticking around to the end. The panel this afternoon, actually each one of them could take up the time we have with the expertise they have. Abby Cohn-Smutney, a partner in the Washington, D.C. office of White & Case, and she co-heads the firm's international arbitration practice. Julie Bedard will be appearing on screen like the Wizard of Oz in a few minutes, heads Skadden's International Arbitration Group of the Americas, and is co-chair of the Arbitration Committee of the IBA. Gene Kalitsky is an arbitrator in New York and in Washington, D.C., specializing in investor-state, international and complex commercial disputes, and has affiliations with a number of providers, institutions. Catherine Rogers, professor of law, focusing on international arbitration, and proud founder of Arbitrator Intelligence. So we are going to move right into the hypotheticals we have planned. They discuss a number of areas involving counsel ethics, excuse me. And the first one, here we go, involves third-party funding. And Abby's going to take us through that one.
Okay. All right. Well, we'll go right into this first hypothetical, which gives us a basis to discuss some interesting issues that are very practical and real. The hypothetical is, well, hopefully you can read it, but in a nutshell, it is a situation in which it's an investor-state arbitration. Claimant has appointed an arbitrator that is also a partner at a law firm. That law firm receives portfolio funding. We'll discuss that in a moment. It's not disclosed, and it later becomes clear that that's what's happening to the state's counsel. And then the question is, should the arbitrator be challenged? And if so, would the challenge be effective? So basically, this hypothetical is raising a number of questions. First, I would say the question is, why do we need to think about disclosing third-party funding at all? Why is the disclosure needed? The primary reason that is usually cited is that this is to avoid conflicts of interest that the arbitrators might have. One might ask, how is that possible? Well, some arbitrators are partners at law firms, others are not, but if you're a partner in a law firm, you might have a conflict relating to a funder because of work that either you or other of your partners is doing. But even if you're not a partner at a law firm, some arbitrators may be providing counsel to third-party funders. They might sit on the board of a funder. They might somehow be affiliated with a funder. And that, too, is not hypothetical. That is, at least there are a number of examples of that. So in order to avoid this type of conflict, the issue is disclosure. So then comes the question, well, who should disclose what and when? But maybe before we get to that, we have the question of, well, what is third-party funding? I think, and this hypothetical gives us a great opportunity to talk about how the concept of third-party funding continues to evolve. Those who, I think most everyone here probably feels that they're familiar with the concept of third-party funding, an investor who invests in, by providing funds to facilitate the presentation of a case and has recourse against the proceeds of an eventual arbitral award, a classic, let's say, single case funding. Portfolio funding, I've recently myself come to learn, is in fact an example of a growing evolution of funding where the funder is actually loaning money or funding a law firm's activities, not any one particular case. And the recourse of the funder is against, in the classic example, against a portfolio of cases. And so this again, in a classic example, because there are so many variations possible, the law firm maybe represents, has some sort of flexible fee arrangement, or the law firm has the matter on contingency with the client, but the funder is funding the firm, which enables the firm to have that flexibility with their fees. And so an eventual award, if collected from a portfolio of cases, is where the recourse that the third-party funder would have against a portfolio of cases. So it's not directly funding any individual case, but a portfolio of cases. And one interesting point I think of immediately is if it's a portfolio of cases, you can imagine there may be a temporal element, and depending on how much money is funded, perhaps the funder is fully satisfied after the result of the first claim, and then the financial interest sort of goes away from the other cases. One can imagine a lot of interesting variations here that just underscore that a portfolio funding arrangement to the law firm really is significantly different potentially than a funder that has a direct interest in a single case. So the question, though, is that considered third-party funding? And I would direct your attention to some interesting different definitions relating to third-party funding. There are the IBA guidelines on conflict of interest, which have a notion of direct interest in a particular case, and there's also then subsequent the ICA report on third-party funding, which I commend to you. And then also importantly in this forum, ICSID's arbitration rules, which are proposed to be amended, also has now a definition of funding, which I'll just suggest to you encompasses this idea of third-party funding as, let's say, portfolio funding, or it appears, I think, to do so. And so in our hypothetical, even the concept of portfolio funding most certainly, or most likely, I suppose you could never be certain, because things just continue to evolve, and never say never, and you never want to say always either. But this is a third-party funding arrangement, and so should one have to disclose it? I think up until recently there's been a significant debate on whether or not disclosure is really necessary. Should it always be required? Should it be required only when arbitrators who presumably have some understanding of whether or not they have a potential exposure to funders? Should we wait until an arbitral tribunal says that disclosure is needed in a particular case? And at least the ICSID rules, and they're not the only ones, the proposed new ICSID rules have come out on the side of the debate saying, no, you just need to disclose. It's simpler, everyone needs to disclose, and one needs to disclose as soon as possible. So then the question is, well, what do I need to disclose? And the general rule is the fact of funding and the identity of the funder, but not necessarily the terms of the funding. And I can imagine that there may be circumstances in which one might have a debate about whether the terms of funding are relevant, but at least my sense is that in the majority of cases, it's hard to imagine why the terms of funding would be relevant, but again, the never say never point. But the general rule now would be, if ICSID's proposed amendments are accepted, that in ICSID arbitration it will be a requirement to disclose the fact of funding, even something as exotic as portfolio funding, would have to be disclosed and disclosed at the earliest opportunity. And so one would then avoid a late discovery. Of course, it's possible sometimes that funding happens in the middle of a case. And that's really very tricky because maybe one of your arbitrators has exposure to this funder, which is just another way, I think, of saying when you're appointing arbitrators, and even if you're not presently funded, I think out of an abundance of caution, the way the rules keep changing and the landscape is changing, I think in the new world we have to, as counsel, ask the arbitrator when you're having that initial inquiry whether or not that person has any possible exposure to different funders, because it may be, and it sometimes happens, that funding happens in the middle of a case, and I think you just are going to want to know that. I'm mindful of the time pressure we're under, so I don't want to take up too much more time, but in our hypothetical, would the state prevail on the challenge in our hypothetical? My sense is the answer is that they would. And I think more likely, however, and maybe I'm wrong about this, but I don't think one would have to go through the process of a challenge. My guess is that if this came out, the arbitrator would resign. That's my sense. How are we doing on timing? Maybe we have, maybe we should discuss this hypothetical before we move on?
Perhaps just for a couple minutes,
Yeah.
right?
I don't know if anyone else had any comments on that. I really just want to underscore, to me, what is really remarkable about this whole subject is how fluid third-party funding is. And just when we think we've understood it and can define it, I guarantee in 5 years there'll be a new form of securitization. And, you know, once you start bundling cases in a portfolio, that can then become, you can have a secondary market on this type of risk. And I'm sure it's just going to get more and more complicated.
I mean, the only thing I would add to Abby's remarks is the importance of clarity about the duty to investigate and not just the duty to disclose. This is already in the IBA guidelines, General Standard 7, and the explanation of it imposes a duty both on counsel and the arbitrator to investigate. And that's important because while the arbitrator and the counsel both have duties of disclosure under the IBA conflicts guidelines, the funder itself is not bound by the guidelines. So the guidelines are not imposing on the funder a duty to inform the counsel it's working with, for example, about its relationships with the arbitrator. And so you're only going to know about the funder's other web of relationship if both counsel and the arbitrator investigate. And as a practical matter, that means counsel, when you're working with a funder, you need to ask them, is there anything I need to know about your relationship with these various arbitrators that we're considering appointing or before whom we may be appearing? If you're an arbitrator and you're considering taking on an appointment, and if there's, particularly if you're affiliated with a firm, it may be less of an issue if you're a private individual. But if there's any doubt in your mind that there may be some affiliation that you or your colleagues have that could be imputed to you with a funder, you need to ask at the time of first investigating the appointment. And that duty to investigate can be tricky at a law firm because law firms have databases of all their clients and all the opposing parties, but they don't necessarily have a prefigured database of all the funders that your partners in a different department in a different office may have worked with on a different type of litigation. And so you have to, I think, affirmatively send emails and so forth. But the duty to investigate is pretty rigorous, and I think clarity is important there.
Okay. I think with that, we will move on to the next hypothetical, which has to do with conflicts of interest and conflicts among ethical rules in different jurisdictions. And Julie Bedard will take on that hypothetical.
Thank you very much. I hope you can hear me.
We can.
Thank you. And I'm grateful for the accommodation, and I apologize to the participants of this conference. I was detained in New York due to a hearing, but here we are, so I appreciate the accommodation. This particular hypothetical that we are dealing here with deals with an ICC arbitration seated in Mexico. And what you see is we have a Mexican party that is, you can think of it as two parties. One is the joint venture and the other is the Mexican party. And what is the issue that we are facing? It is that the attorney representing the Mexican party formerly was a lawyer to the joint venture. So in an arbitration where you have joint venture versus Mexican party, the lawyer of the Mexican party formerly represented the joint venture. And you can assume for our purposes that this prior representation would constitute a conflict of interest by U.S. standards. On the other hand, the Mexican representative is stating that two things. Number one, as the Mexican representative of the Mexican party here, I am not, in fact, licensed to practice Mexican law. I'm not a member of the Mexican bar, on the one hand. And on the other, even if I were, the Mexican bar rules do not prevent me from having had this prior representation of the joint venture and today representing the Mexican party in the arbitration. So what do we do here? I think Catherine Rogers teed up a few issues that are very relevant for us, and I should, on this panel, I should really recommend to everyone the read of her book on ethics in international arbitration. I think this is really a must for anyone who is facing any kind of ethical issues in international arbitration. You should start with reading Catherine's book. Well, you may also want to consider, and this is obviously a statement that I make being conscious of the fact that I'm co-chair of the IBA Arbitration Committee, you might also want to consult the IBA guidelines on party representation. And the first question that we raise here is what kind of guidance the IBA guidelines might provide in the situation that I described. So looking at the guidelines, there's, the specific scenario that we just discussed is not one that is addressed with any kind of specificity in the guidelines. But it's important to bear in mind that, generally speaking, misconduct is defined as either a breach of the guidelines, which, again, do not address specifically this scenario, but the misconduct can be any other conduct that the tribunal determines is contrary to the duties of a party representative. That's the definition of misconduct. It's also important to bear in mind, and this was critical in the preparation of the guidelines, and Catherine Rogers and I did a significant amount of work in the preparation of these guidelines. They, they do not displace otherwise applicable mandatory laws. It's important always to remember that the guidelines, and taking a step back here, remembering that the IBA is the organization of all of the bars of the world, right? It was certainly not the place of the IBA as the organization of all of the bars around the world to take the place of the individual member state bar associations in what they wish to be the regulation of the conduct of attorneys in their jurisdiction. I left a video feed on my end, but hopefully you can still see me.
We can't see you, but we can hear you. So.
Okay. All right. So the voice, it will be. So the guidelines are not intended to derogate or undermine a party representative's primary duty of loyalty to a party. And at the very tail end of the IBA guidelines, which deals with remedies for misconduct, there is a very broad potential authority that may be exercised by the tribunal to remedy any misconduct on the part of a party representative in the arbitration, taking into account the potential impact of a ruling and the nature and gravity of the misconduct. So all of this begs the question, of course, of whether and in what circumstances a tribunal may wish to intervene, to make a decision about a specific scenario of conflict of interest, such as the one that I described earlier, whether it should exercise a power under those circumstances. And I think it is very useful in that context to make reference to some decisions and some ICSID cases specifically. We do have, as always, a little bit more access to information when it comes to ICSID decisions and the thinking of tribunals. Specifically, I'd like to make reference to two decisions here for the benefit of the audience, namely the Haska decision against the Republic of Slovenia and the Fraport case. And maybe starting with the latter, in the interest of time, it's useful to consider the decision in Fraport that considered an annulment, and I think it's interesting to have Carolyn Lamb of White and Case, who was involved with that case. In that specific instance, what happened is that Eric Schwartz, who at the time really was with Freshfields, obtained the representation of the Philippines for a very short period of time, but did, for what the arbitrators in that annulment application called a stillborn representation or retainer, it did act for some limited period of time for the Philippines, and nevertheless sought to represent the Philippines in what was the related ICSID matter. And in that specific instance, the tribunal was faced with, not an easy decision of what to do with the fact that Eric Schwartz specifically and Freshfields as a firm represented, he really had this double representation, as it were, going from one side to the other of the V. And where the committee thought that it should focus its analysis on was to analyze the facts that led to the allegation of the conflict of interest. So there is a significant discussion by the annulment committee with respect to that. They go into what information Freshfield may have received, if any, concluding ultimately that it had not really received a lot of confidential information. The committee does note that the ICSID system is a self-contained system for the arbitration of investment disputes, which is not subject to national law. But it does take great care in focusing on the fact that any question of procedure, including the management of the proceeding, including what may be potential misconduct, including what may be a potential conflict of interest, is something that the tribunal should focus on as part of its case management responsibilities, in parallel with what may be an ethical discussion for the local bars to handle. So in that particular instance, I quote, the committee considered that it had the power and duty to conduct the process before it in such a way that the parties are treated fairly and with equality, and that at any stage of the proceedings, each party is given the opportunity to present its case. And significantly, in the mind of the annulment committee, this means the power and duty necessarily includes power and obligation to make sure that the generally recognized, this is interesting, generally recognized principles relating to conflict of interest and the protection of the confidentiality of information imparted by clients to their lawyers are complied with. So what you are seeing here is a rather clear statement on the part of the annulment committee that there's a recognition that it doesn't have any ethical regulatory responsibility that belongs to the local bars, but through its case management and procedural responsibilities, the tribunal feels that it is in fact empowered to deal with what would be generally recognized principles of conflicts of interest and the protection of confidentiality of information. So no deontological responsibilities or jurisdiction over the parties, but definite case management responsibilities. And in that particular instance, as I noted earlier, the tribunal did proceed to look at the information that was before it with respect to how long the representation that was creating the conflict of interest lasted, and whether, in fact, Eric Schwartz and Freshfields had acquired confidential information by the Philippines before it began to represent Fraport, that was the claimant in that particular case. So the question that I think Catherine had identified for us that you may have seen on the slide describing this hypothetical was whether the tribunal has the power to disqualify the Mexican counsel. I highlight here the technical answer and the practical answer. The technical answer with respect to the power to disqualify is really one that is the deontological responsibility that the Fraport Tribunal said it didn't have. I take the opportunity to note that the New York courts have jealously reserved and preserved their jurisdiction to rule on such matters, and it's not always well known. And they're domestic arbitration cases as opposed to international arbitration cases, but the New York courts have made it clear that they fully expect the New York courts to deal with these issues as opposed to arbitration tribunals. The IBA guidelines have taken great care in not taking a position, allowing each tribunal, in whichever venue it may be seated, to make this decision about whether, in fact, it has this power to disqualify counsel. We have seen tribunals disqualify counsel in the more controversial and well-known cases of a counsel in the arbitration being admitted late to the case and being a member of the chambers in the United Kingdom of one of the arbitrators. So that situation has been seen. I have not seen much more beyond that when that specific scenario is addressed in the IBA guidelines. So perhaps, we can stop here the description of this particular scenario, and we welcome any discussion, any questions about the scenario itself, or the broader discussion with respect to the powers of the tribunal to address potential conflicts of interest and applications for counsel to be disqualified.
Thank you, Julie. So again, maybe just a minute or two, any reactions or thoughts?
So we are, I think everything Julie said was actually terrific as setting it up. One thing I will add is that it's actually very common that one side's counsel is not subject to the kind of oversight that some bar associates. There's not only a discrepancy between the substance of the rules, but also the levels of enforcement, the potential remedies. And that's what this sets up, because actually Mexican attorneys, you can be an attorney and you do not have, there's no obligation that you get licensed formally or that you be a member of the bar. And of course we know that you don't have to be an attorney even to be a representative, which is why the name is party representation as opposed to counsel or attorneys. There are a number of different ways that we see essentially an imbalance, an unlevel playing field that's set up as a result of counsel ethics or conflicting ethics among different jurisdictions from which counsel come. Given the time, that's all I'm going to say, because the next two hypotheticals also deal with essentially these imbalances and how the IBA guidelines seek to try and create some balance or rectify the imbalance.
And that's the perfect segue. Hypothetical 3 relates to issues in connection with document production. And Jean is going to start us with that.
Thank you. So first of all, my thanks to Catherine, who, as you've probably detected, devised these scenarios for us. And there's a very gratifying reason that we're actually working off of hypothetical scenarios and not sharing a series of horrible war stories with you from our own respective practices as counsel and arbitrator. And that's because in an early planning call, when the subject of war stories came up, we proudly or sheepishly, as the case may be, confessed to each other that despite our long careers and having experienced a wide range of degrees of zealous advocacy and sometimes even sharp elbows, perhaps, from opposing parties or parties appearing before us, we had not really been plagued with horrible instances of truly unethical conduct by counsel. We had not had those experiences. We were very pleased to not have those. And so if we're in any way representative, at least a couple of us on this panel, it tells us that the bad stories are hopefully the minority and not the majority, and that's something to take pleasure from. But in any event, my thanks to Catherine for developing the scenarios that we're working with. So the third one really is an issue of uneven playing fields, and at least in one or two respects, is something that actually comes up in real life. So it involves AAA ICDR arbitration seated in Milan between a U.S. company on the one hand and a German company on the other. The U.S. company is represented by Brazilian counsel. The German company is represented by English counsel. So what you see right off the bat is a common law company with a civil law attorney and a civil law company with a common law attorney. The U.S. party seeks in document production in-house counsel documents from the German company, arguing that under German law, in-house counsel are not members of the bar, as is true in many civil law countries. They're not strictly avocat, they're not members of the court bar, and therefore are not strictly privileged under German rules on privilege. The German company, represented by English counsel, responds that the U.S. company has itself invoked privilege to protect documents created by its in-house counsel, which would be covered by U.S. law on privilege. And the question is, how does the tribunal rule on it? And this is a particular hypothetical which does come up in real life. It's you could say a rule of evidence rather than a rule of ethics, but obviously the challenge in arbitration is to design a process that does justice not just to the different expectations of the parties, but also the different ethical obligations of parties and counsel appearing before you while ensuring a level playing field. And this is a very real-world problem. And it arises in courts, and in case you, for example, hadn't heard this, Microsoft a number of years ago found itself on the losing side of this very battle about in-house counsel, and it ended up having to turn over to EU competition authorities certain in-house counsel documents that had been created in its European offices, which it had wrongly assumed would be covered by attorney-client privilege, because they would have been at Microsoft's headquarters in the U.S. So this is a real problem. There are some delicate embedded choice of law issues which are too complex to go into given the limited time here. They basically boil down to what might be called a where approach, a who approach, or a how approach. A where approach tries to identify the laws of a single jurisdiction. Is it the law of the seed, or the law where the documents were created, or the lawyer in question, or the client in question, and so forth. A who approach might look to the expectations of confidentiality by the people who were involved in the creation of the document, and maybe there aren't privilege rules as such applicable to that relationship, but there may be other expectations of confidentiality flowing from limited discovery, for example, in that jurisdiction. And what I'd call a how approach looks at process-based norms like equal treatment and takes you outside of the let's identify a jurisdiction that governs. The IBA rules have a multi-factor test, Article 9.3, that more or less says a tribunal can consider all of these elements. I won't read to you the test in the interest of time, but it identifies all of these factors. It doesn't put a thumb on the scale. The hypothetical, however, as you will see, is a AAA ICDR arbitration, and that's an important factor for this scenario because the ICDR rules in their Article 22 are, I think, close to unique in institutional rules in making in advance a policy choice and not just leaving this to the unfettered discretion of the arbitrators. So they say that tribunals should take into account applicable rules of privilege, but where the parties, their counsel, or their documents would be subject under applicable law to different rules, the tribunal should, to the extent possible, apply the same rule to all parties, giving preference to the rule that provides the highest level of protection. So what the rules are basically doing is elevating equality of arms considerations over a strict choice of law analysis that identifies one jurisdiction or the other as dominant. You could say it's a sort of a most favored privilege rule. And the notion is that, I guess, that between two potential levels of equal treatment, the possible overprotection of one side is better than the possible underprotection of the other. I'm a big fan of the clarity that flows from that approach, and I've seen tribunals essentially opting for it even under the IBA rules, which don't require them to. So that's, I think, all I'll say as an introductory remark. But.
And Kathy, you're going to take the second part of this.
Okay, so I'm going to actually, as the last speaker, use the last speaker prerogative to not do the last hypo. And I'm going to instead use it as an opportunity to just look a little bit forward about what I think we might be seeing in the area of ethics and development. So I think the panel has set up very well. First of all, there are a number of things that are definitionally vague. The evolving definition of third-party funding, and I think it's one thing to come up with a rule, okay, you need to have this disclosed. I think the hard part's going to be looking to the future. How do you define who has to be disclosed? Because the mechanisms and the structures are evolving constantly. So by the time you come up with a definition, they've come up with a new structure to work around that definition. That, I think, is going to be one of the challenges with third-party funding. With regard to counsel ethics, and I thought both Julie and Jean did a fantastic job of working us through these hypotheticals. Jean's exactly right. It's not a question of radical misconduct most of the time. It's a question of one side thinking they have a right or an ethical obligation to do something that the other side thinks that they're either prohibited or shouldn't do. And that's where I think most of the action is. That's why the IBA guidelines on party representatives have been so important. But it's really fascinating to me, those guidelines were enacted in 2014, actually right after my book went to the publisher. So my book is already very much outdated. Thank you, Julie, for suggesting it, but I am working on a second edition that hopefully will be coming out in 2020, I think. But I think one of the things that we're going to see with counsel ethics is, notwithstanding the reluctance of tribunals to weigh in, I think Charlie Brower, seated here in the front row, in the Hep versus Slovenia case, led the way in taking a pretty strong stance about arbitrator powers. My sense is we might see some movement on that, even if we see an equally reluctant opposition to arbitrators taking on that role on the other side. We will see, I think, some revisions perhaps in the future with regard to the IBA guidelines. They, like the conflicts of interest guidelines, they might go through another edition. The hypo that we're not seeing is because it deals with document production, which is one of the areas where there was the most controversy when the guidelines came out. This is the area where civil law and common law attorneys clash the most vigorously. And my sense is we might see some evolution there as well. One thing I am quite sure of in the future of ethics and international arbitration is these questions are not going away. Despite the fact that we've been debating them now for all of my career, the discussion has gotten more nuanced, more sophisticated. We have more examples. We're digging down deeper, but we're not necessarily getting a strong consensus. There remains a great deal of debate, which I was just reminded of by the chairman of the Swiss Arbitration Association I saw at another conference recently. So with that, I think I'm going to just turn over my microphone to Eric for concluding remarks.
Okay, well, thank you. So everybody's gotten a bargain this afternoon. You got an hour-long presentation condensed to about 40 minutes, but the same content. The speakers were wonderful. And I think we're going to wrap it up at this point. Thank you all very much. If we could give a round of applause to the panelists.